Hello everyone and welcome to NLTI. Today we are meeting again to continue our series of understanding how do you have to prepare for legal reasoning for CLAT UG preparation. The exam is just around the corner, very less time is left, and I really hope that your preparation is coming along good so far. Now we are here because we have to understand something extremely important about your legal reasoning section, one very important topic, one very important concept, one very important subject, which is law of torts. I know this for a fact that you're aware that it is one of the most important areas to prepare for CLAT UG, and also it is going to be one of the very first subjects that you will be studying in your law school whenever you join your law school. So a lot of times I've seen people struggling in this section specifically. They're not sure what is this section for, what are they studying, what is how this entire law functions, and that is something which we have to understand today. And we also have to touch upon a few concepts that are extremely important for you to prepare for your exam. Now, to understand, to get started with, first of all, let us just understand what is law of torts. Now, something really simple can happen to you or can happen with you, right? Or can happen to anyone, and maybe you are responsible for the same. It can be something really what can we call it, something really unexpected, something unforeseeable, something which is inevitable, right? But still, if any damage has happened to someone, be it you or be it anybody else, and that damage is something which is unpredictable, it is not something which is criminal in nature, it is something which nobody could foresee, it is also something which nobody could avoid, right? In that case also, if any sort of damage has happened to someone, that person is a victim. Now he deserves justice, he deserves compensation, he deserves some remedy out of the same. Now, to give remedy for any such offense, not exactly offense, any such civil wrong for which there is no specific law that we have, right? So in that case, we use law of torts specifically. Now, what do I mean by that? Let's understand. Now, let's say you are a dog owner, you have a ferocious dog at home with you, and now your dog bites a visitor, right? Or maybe your dog bites a neighbor. So in that case, you have not done anything directly, but still some loss, some damage has happened to some other person because of you, or maybe because of something that you have with you. So in that case, you will have some responsibility towards that person. Yes. Now, second is that, okay, let's say there is a newspaper that has published false allegations against somebody else. Again, this is something which is wrong and it needs a remedy, it needs justice. Then your friend fails to repay the borrowed money. In that case, what can be done? Okay. Or if a person parks on another person's land without permission. So this is not exactly a crime, but still it is injury of a legal right. So in that case, what can be the solution? All of the same has been in detail explained to us under law of torts. So any such incident happens, any such legal injury of civil nature happens to any person, right? In that case, the remedy for the same, the solution for that legal injury is given to us under law of torts. So law of torts specifically talks about all these losses that can happen, right? Which is unforeseeable, which is not something anybody can predict, right? So now what is a tort? Now under criminal law, we have something called a crime, right? If a crime is going to happen, only then criminal law is going to be applicable. Same way, under law of torts, there is something called tort. If a tort is going to exist, only then law of torts will be applicable. Now, what is a tort? Let's just quickly understand the same. Tort is a civil wrong. One thing is very clear that nothing criminal is happening here, okay? It is purely civil in nature. So, tort is a civil wrong, right? For which law provides a remedy, most commonly in form of damages. Damages means compensation. यहाँ पे एक चीज बहुत हमें याद रखने की जरूरत है कि कंपनसेशन मिलता है. कंपनसेशन ऑल्सो कंपनसेशन इज इन नेचर ऑफ अनलिक्विडेटेड डैमेजेस, यानी कि compensation which is not prefixed, which is not pre-decided, right? ऐसा loss अगर आपका होता है जिसमें you cannot predict and you cannot anticipate how much damage has happened, right? In that case, we have law of tort that is applicable. Now, it arises independently of any agreement between the parties and the obligations. So it does not matter कि कोई भी agreement हो या ना हो. Most of the times when there are no agreements and then any sort of civil wrong that happens, right? So if in that case law of torts, it becomes applicable automatically. Okay. So now why do we have law of torts? To protect the private rights. Like I mentioned, कोई बहुत छोटी चीज भी अगर होती है या कोई भी ऐसी चीज होती है जो कि which is not contractual in nature या कुछ भी और गलत होता है, even in that case also somebody's legal rights are being violated, right? So somebody's legal rights are being violated. Unliquidated means something which is not decided already, which is not pre-decided. ठीक है? Unliquidated means something which is not pre-decided, which is not prefixed. जैसे if there is a contract में usually it is mentioned, there is a clause कि अगर दोनों parties में से कोई चीज को नहीं मानती है, कोई भी conditions fulfill नहीं करती है, then this is going to be the consequences. The other party who is not obeying to the conditions might have to pay this much money to the other party. Now, in law of torts, there is no such condition. There is no such uh, prefixed amount that is decided, right? So that is called as unliquidated damages, something which is not pre-decided. Okay. All right. Now, why are we doing this? To compensate the victims. Now, see, किसी ना किसी तरह की legal injury तो definitely हुई है. Now, let's say you're driving on the road and you bump into someone else's car. This is not something that you have pre-decided. This is not something that you have pre-planned. आप अपने घर से ये सोच के नहीं निकले थे कि you are going to bump into someone's car and you're going to damage somebody's car, but you have done it now, right? तो कितना compensation देना होगा, कौन सा लॉ एप्लीकेबल होगा, इसके लिए वी डू नॉट हैव एनी क्लियर लॉ, कोई लेजिस्लेशन नहीं है हमारे पास. दैट्स व्हाई वी हैव लॉ ऑफ टॉर्ट्स. So for any such civil wrongs, अब इसमें भी something really important is that it has to be civil in nature. Any such civil wrong that happens, okay, for which there is no remedy given to us in any specific legislation, but still कोई भी legal injury हो गई है तो उसमें justice देना ही पड़ेगा. That's why we have law of torts to compensate the victim. So अब किसी के साथ भी अगर कुछ गलत हो गया है, then we have to compensate that person, right? For the same, we have law of torts. Now, okay, let's understand the essential elements and let's just understand it very simply. First thing is that there has to be any wrongful act or omission. दो चीजें यहाँ पे बोली गई हैं. One is an act, second is an omission. Act का मतलब होता है to do something, right? If you're acting some way, if you're acting careless, right? Or if you're acting basically means you're doing something. What are we saying here? Wrongful act. कुछ भी ऐसा करना which is not correct. Doing something which is not correct, doing something wrong. Okay? Wrongful act. Omission means not doing something which you are supposed to do. Now let's say, right, let's say you are a school student and it is your responsibility to go to the school every day, but you do not do it. So you have done an omission here. Let's say you left your house to go to the school, but you do not go to the school, you bunk your school, right? So यहाँ पे your responsibility was to go to the school. That was your duty, but you do not do it. When you do not perform your duty, you are doing an omission. ठीक है? So when you are doing something wrong, that's a wrongful act. When you are not doing something which you are supposed to do, that's an omission. So now when you do any wrongful act or omission, right? तब सबसे पहली चीज तो लॉ ऑफ टॉर्ट्स एप्लीकेबल उन सिचुएशंस में होगा जहां पे कोई भी wrongful act या omission हो रहा है. जहां पे कोई wrongful act हो ही नहीं रहा, कोई omission हो ही नहीं रही, वहां पे लॉ ऑफ टॉर्ट्स ऑटोमेटिकली एप्लीकेबल नहीं होता है. सेकेंड थिंग दैट देयर हैज टू बी एन इंजरी. अब आपने जो भी wrongful act किया है या wrongful omission किया है, उसकी वजह से देयर शुड बी एनी लीगल इंजरी दैट शुड हैपन. लीगल इंजरी का मतलब क्या है? लीगल इंजरी का मतलब यहाँ पे ये नहीं है कि आपको चोट लग जाए, आपका सर फट जाए, आपका खून निकल जाए, जी नहीं. लीगल इंजरी मीन्स आपका कोई राइट, एनी लीगल राइट दैट यू हैव दैट हैज बीन वायलेटेड. Okay, it can be anything. It can be you maybe getting deprived of using something that belonged to you, right? For example, now you were driving on the road and somebody comes and bumps into your car. You had a right to drive safely on the road, to be safe on the road. Now someone comes and bumps into your car because they were careless and they were negligent. In that case, it's not your fault, but still your legal right has been breached. आपके साथ तो legal injury हो गई है, right? Anything that is legally wrong that has happened to you is a legal injury. Okay, so now you've done a wrongful act and उसकी वजह से there is a legal injury that has happened. अगर आपके wrongful act की वजह से कोई भी legal injury नहीं होती है, then law of torts automatically is not going to be applicable. I'll explain you how. Let's say you're driving on the road. Now, it is your duty. It is your duty to drive safely, right? Whenever you drive on the road, it is your legal duty to drive safely. Speed limit में drive करो, traffic rules को मानो, गाड़ी ऐसे चलाओ कि खुद को भी नुकसान ना हो, किसी और को भी नुकसान ना हो. This is something which is expected out of you, which is very basic. Now, if you, let's say, start driving really negligently, right? You're recklessly driving, you're doing rash driving, you're over speeding. Let's say you're driving at a speed of 160 kmph and you're driving negligently. Now, उसमें दो situations हो सकती है. One is that you might get into an accident, right? If there is an accident, तब तो बहुत सारी legal situations हो सकती है. Second situation is nothing happens. You're driving negligently, but God was kind and nothing happened, right? So in that case, no legal injury has happened. So अगर कोई legal injury हुई ही नहीं है, in that case, law of torts पे applicable नहीं होगा. तो दोनों चीजों का exist करना जरूरी है. One, there has to be a wrongful act or omission. Second, there has to be a legal injury. Both of them have to coexist. Okay. Third, we have to have any legal remedy for the same. Now, what is the legal remedy? How do we get into the same? I am going to explain it to you in a while. Okay. Now, okay. So this much is clear that यहाँ पे हमारे पास कोई भी act या omission होना चाहिए और उस act या omission की वजह से there should be any legal injury that should also happen. Now, let us just quickly understand few differences between law of torts, between torts, crime, and contract. देखो, one thing that should be clear in your head is tort and contract. ये दोनों civil law का part है. अब I'm not sure if you are aware of the same or not, but there are broadly two branches of law: civil and criminal. Right? Civil is when any dispute that is happening between two individuals, A versus B, private persons. ठीक है? राम वर्सेस श्याम, सीता वर्सेस गीता, राइट? इसमें गवर्नमेंट का कोई लेना देना नहीं होता. जैसे कि कॉन्ट्रैक्ट्स, whenever you are entering into a contract, either you are entering into a contract with one person or maybe you are entering into a contract with any company or any corporation, right? So इसमें गवर्नमेंट का कोई लेना देना नहीं है. That is civil law. Divorce, adoption, पार्टीशन, राइट? कोई भी प्रॉपर्टी डिस्प्यूट होता है, दो भाइयों के बीच में प्रॉपर्टी डिस्प्यूट है, गवर्नमेंट का कोई लेना देना नहीं है उसमें. सो सिविल लॉ इज व्हेन द डिस्प्यूट इज बिटवीन टू प्राइवेट इंडिविजुअल्स. देन वी हैव क्रिमिनल लॉ. क्रिमिनल लॉ में वन पार्टी इज अ सिटीजन, एन इंडिविजुअल. Second party is always the government. Now let's understand this, how that happens. See, criminal law में you कभी भी if you will ever come across any criminal case, उसका नाम हमेशा ऐसा होगा: A versus state of किसी भी स्टेट, लेट्स से स्टेट ऑफ दिल्ली, राइट? या फिर A versus यूनियन ऑफ इंडिया. सब इसका मतलब क्या होता है? इसका मतलब है कि आपके पास जो एक पार्टी है वो कोई प्राइवेट इंडिविजुअल है, दूसरी पार्टी इज द स्टेट, इज द गवर्नमेंट. व्हाई? अब इसमें कैसे रहता है कि ये जो पार्टी, जो प्राइवेट इंडिविजुअल है, ही इज द अलेजेड क्रिमिनल. अभी तक प्रूव नहीं हुआ, इसलिए हम वर्ड अलेजेड को यूज करेंगे, राइट? समवन हु हैज एलिगेशंस ऑन हिम, अलेजेड क्रिमिनल. एंड अदर पार्टी इज स्टेट. State यानी कि government. Now, why do we have government as another party? Government represents the victim, and this person is the accused, right? Accused को हम अलग से mention करते हैं, and government जो है वो victim को represent करती है. Victim को इसलिए represent करती है because it is always said that whenever a crime happens, a crime always happens against the entire society. It's not just against one person, it is against the entire society. एक crime होता है तो उससे पूरी society में दहशत हो जाती है कि जी ऐसा हो गया, right? So, and it is the responsibility of the state and the government to ensure that this does not happen ever again. That's why the state represents it. So, वन थिंग इज दैट टॉर्ट एंड कॉन्ट्रैक्ट दोनों ही सिविल लॉ का पार्ट है. ओके, नाउ इफ लेट्स से सिविल लॉ इज दिस, then law of torts is one component, same way कॉन्ट्रैक्ट इज ऑल्सो अनदर कॉम्पोनेंट, राइट. इस तरह से और भी बहुत सारे सिविल लॉ के पार्ट्स होते हैं. क्रिमिनल लॉ इन इटसेल्फ इज अ डिफरेंट ब्रांच ऑल टुगेदर. ओके, सो टॉर्ट एंड कॉन्ट्रैक्ट दोनों ही सिविल लॉ से रिलेटेड होते हैं. सिर्फ अब इनमें डिफरेंस क्या है? इनका मतलब है कि टॉर्ट इज अबाउट मच मोर अबाउट प्राइवेट रॉन्ग्स. किसी भी इंडिविजुअल के साथ किसी दूसरे इंडिविजुअल ने अगर गलत कर दिया है, दैट इज गोइंग टू बी पार्ट ऑफ टॉर्ट्स, राइट. क्राइम, लाइक आई सेड, इज अ पब्लिक रॉन्ग. इवन इफ वो किसी एक इंसान के अगेंस्ट ही क्राइम हुआ हो, तब भी हम यही बोलते हैं दैट क्राइम हैज ऑलवेज इट ऑलवेज हैपेंस अगेंस्ट द एंटायर सोसाइटी, राइट. सो इट इज कंसिडर्ड एज अ पब्लिक रॉन्ग. कॉन्ट्रैक्ट ऑन द अदर हैंड इज अ ब्रीच ऑफ अग्रीमेंट. कॉन्ट्रैक्ट का मतलब क्या होता है? कॉन्ट्रैक्ट में, इफ यू नो, कॉन्ट्रैक्ट मीन्स अग्रीमेंट, राइट. कि दो पार्टीज डिसाइड करती हैं कि हम ये चीज करेंगे, हम ये चीज नहीं करेंगे. अगर आप ये चीज नहीं करते हो तब आपको मुझे इतना कंपनसेशन देना पड़ेगा. अगर आप ये चीज नहीं करोगे तो मैं आपको कोर्ट में लेके जा सकता हूँ. आपने बेसिकली कुछ चीजें आपस में डिसाइड कर लिया, म्यूचुअली अग्री कर लिया, राइट. आप उन्हें नहीं मानते हो तो फिर एक कॉन्ट्रैक्चुअल डिस्प्यूट हो जाता है. टॉर्ट ऑन द अदर हैंड इज नॉट अबाउट कॉन्ट्रैक्ट. इट्स अबाउट कोई भी ऐसी प्राइवेट दो इंडिविजुअल्स के बीच में कुछ भी ऐसी घटना हो जाना जिसकी वजह से एक इंसान दूसरे का कोई भी नुकसान कर देता है. इन दैट केस जिसका नुकसान हुआ है उसे कंपनसेशन कैसे मिलेगा, दैट इज समथिंग विच लॉ ऑफ टॉर्ट्स हेल्प अस विद, राइट. लॉ ऑफ टॉर्ट्स की प्रोसीडिंग सिविल कोर्ट में होती है, कॉन्ट्रैक्ट्स की भी सिविल कोर्ट में होती है. क्रिमिनल लॉ की वी हैव क्रिमिनल कोर्ट्स. इफ यू विल नो दिस, when you start reading law you will understand कि civil law और criminal civil courts and criminal courts भी अलग अलग होते हैं. These are not the same courts. ठीक है, कोई भी सिविल डिस्प्यूट होता है वो अलग कोर्ट में सुना जाता है, क्रिमिनल केस अलग कोर्ट में सुना जाता है. ओके, नाउ फॉर टॉर्ट्स, अगर कोई कोई भी टॉर्ट हो जाता है, ठीक है, उसके लिए सोल्यूशन इज कंपनसेशन, राइट. मोस्ट ऑफ द टाइम्स हम क्या करते हैं, पैसे देते हैं. अगर मैंने आपका नुकसान किया है, अगर मैंने आपका फोन तोड़ दिया है, तो या तो मैं आपको नया फोन ला के दूंगी या फिर मैं आपको उसके उसके लिए मैं आपको पैसे, आई कंपनसेट यू फॉर द सेम, फॉर व्हाट ऑल डैमेजेस हैव हैपेंड. यू आर नॉट गोइंग टू, यू विल नॉट सेंड मी टू द जेल बिकॉज आई broke your phone, right. That's not the solution. That's not going to help you. That's not going to help me, right. And that is unnecessary burden on the government as such. So whenever there is a tort, the solution is compensation, which I said unliquidated damages, यानी कि जो कि pre-decided नहीं है. अगर 5,000 का नुकसान हुआ है तो 5,000 कंपनसेशन मिलेगा. 10,000 का नुकसान हुआ है 10,000 कंपनसेशन मिलेगा. 5 लाख का हुआ है तो 5 लाख. तो इट वेरीज केस टू केस. कॉन्ट्रैक्ट में भी आपको कंपनसेशन मिलता है, राइट, बट इट इज प्री डिसाइडेड, राइट. इट इज लिक्विडेटेड, यानी कि वो ऑलरेडी डिसाइडेड है. आप जब भी कॉन्ट्रैक्ट करते हो, कॉन्ट्रैक्ट में आप डिसाइड कर लेते हो ये चीज कि अगर आपने मेरी ये कंडीशन नहीं मानी देन यूल हैव टू पे मी दिस मच ऑफ मनी, राइट. जैसे कभी तुमने सुना होगा कि देयर आर एम्प्लॉयमेंट बॉन्ड्स. एम्प्लॉयमेंट बॉन्ड्स में क्या होता है कि कॉन्ट्रैक्ट होता है एम्प्लॉयर और एम्प्लॉय का कि अगर आपने 2 साल के अंदर अंदर ये जॉब छोड़ दी देन यू विल हैव टू पे अस दिस मच मनी. द एम्प्लॉय हैज टू पे द एम्प्लॉयर दिस मच ऑफ मनी. तो इस चक्कर में वो बेचारे जॉब ही नहीं छोड़ पाते. दैट हैपेंस. दैट्स अ कॉन्ट्रैक्ट, राइट. नाउ अंडर क्रिमिनल लॉ देयर इज समथिंग कॉल्ड पनिशमेंट. पनिशमेंट का मतलब है कि यहाँ पे आपको पनिशमेंट में आपको यहाँ पे जेल हो सकती है. आपको किसी भी सिविल रॉन्ग के लिए जेल नहीं होती. आपको टॉर्ट्स या कॉन्ट्रैक्ट्स या डिवोर्स में भी यू विल नॉट हियर कि आपको कभी जेल होगी, नहीं होती है उसमें जेल. बट अगर आपने कोई क्राइम करा है, लेट्स से एक डिवोर्स प्रोसीडिंग के साथ साथ यू गेट टू नो कि वहां पे डोमेस्टिक वायलेंस हुई है, डोमेस्टिक वायलेंस इज अ क्राइम, तो उसके लिए जेल हो सकती है, राइट. डाउरी, डाउरी इज अ क्राइम, उसके लिए जेल हो सकती है. बट अगर आप डिवोर्स डिमांड कर रहे हो तो उसके लिए जेल नहीं होगी. व्हाई? बिकॉज इट्स अ सिविल रॉन्ग. तो सिविल केसेस में जेल नहीं होती, क्रिमिनल केसेस में जेल होती है. सो वन थिंग इज, क्योंकि टॉर्ट इज पार्ट ऑफ सिविल लॉ, तो इसमें भी जेल नहीं हो सकती. ओके, चलिए आगे बढ़ते हैं. Some really important maxims under law of torts. First is ubi jus ibi remedium. It says where there is a legal right, there is a legal remedy. अगर आपके पास कोई भी राइट है, तो अगर वो राइट वॉयलेट हो जाता है तो उस वॉयलेशन के लिए आपको कुछ ना कुछ जस्टिस भी मिलने का प्रोविजन हमेशा होगा. ठीक है, अब इसका मतलब क्या है? फॉर एग्जाम्पल, now you have fundamental rights. ठीक है, अब तुम्हारे पास fundamental rights है. If you know, you have 6 fundamental rights, and those fundamental rights में से एक fundamental right is right to constitutional remedies. अब इसका मतलब क्या है कि अगर तुम्हारे पास टोटल कुल 6 fundamental rights है, अगर तुम्हारे पास ये जो 5 फंडामेंटल राइट्स है उसमें से कोई भी फंडामेंटल राइट वायलेट हो जाता है, तो तुम्हारे पास एक 6th फंडामेंटल राइट है विच सेज कि अगर आपके ये 5 में से कुछ भी वायलेट हो गया, देन यू कैन गेट अ कॉन्स्टिट्यूशनल रेमेडी, यानी कि आपको जस्टिस मिलेगा टू व्हाट, because your fundamental right is violated, right? Same way law of torts में भी क्या maxim use होता है, it says कि अगर आपके पास कोई भी benefits है, right? तो अगर कोई भी वो benefits आपसे छीन लेता है तो आपको justice मिलेगा. It's as simple as that. If you have any privileges, any benefits, and those benefits are taken away from you by someone else, right? Wrongfully, then you are liable to get justice for the same. This is what this maxim says. Right? Where there is a law, there is a remedy. Now, इसमें हमारे पास एक बहुत इंटरेस्टिंग केस है, which is Ashby versus White, a judgment of 1703. अब इस जजमेंट में हुआ क्या था? Let's understand. इसमें क्या हुआ था? Ashby, who was the plaintiff, right? Ashby was a voter. He was a qualified voter. He could cast his vote. Now, he wanted to cast his vote for the parliamentary election. Now he was wrongfully prevented by White. White कौन है? White वहां पे एक election officer था, right? And he wrongfully stopped Ashby from casting his vote in the parliamentary election. Now, if you know that you have right to vote, ये तो 1703 का एक judgment है, ठीक है? उस समय we're not talking about India specifically, or this is also a foreign judgment. Most of the judgments under law of torts are going to be from English law. Right? So Ashby versus White में what has happened now? Parliamentary elections से Ashby के पास right to vote है. He had right to vote, but he could not cast his vote because White stopped him from doing so. So now he went to the court and he said that I was not able to cast my vote. I have my right to vote. My right to vote has been violated. So now here the court said that okay, yes, you had a right, okay, and your right has been taken away from you. So you deserve justice for the same. And this is exactly what this maxim also states, that where there is a right, there is going to be a remedy. If your rights are taken away from you, you are eligible to get some justice for the same. Okay. The next two very, very important maxims are damnum sine injuria and injuria sine damno. Now, okay, what does it mean? Damnum sine injuria, it means damage without legal injury. डैमेज का मतलब है नुकसान, एनी सॉर्ट ऑफ लॉस. लीगल इंजरी यानी कि violation of any rights. So there can be a lot of such situations where you might suffer some loss or might suffer some harm, but not necessarily any legal right might be taken away from you. Now what does it mean? Let's understand it in detail. अब there is a judgment called Gloucester Grammar School case. अब इसमें क्या हुआ था? There was this school, let's just call it GGS. Right, GGS was a school in a locality. It had monopoly. यहाँ पे इसके अलावा और कोई बढ़िया स्कूल नहीं था. Best amazing school. उस एरिया के जितने बच्चे थे इस स्कूल में पढ़ने आया करते थे. Now इसका एक another school इसी की vicinity में एक और स्कूल इसके राइवल ने खोल लिया. राइट नाउ अब इससे क्या हुआ, जो भी पहले बच्चे थे वो सिर्फ जीजीएस में आया करते थे, अब वो स्कूल ए में भी जाने लग पड़े. सो क्लियरली यहाँ पे क्या हुआ, जितने उसको फाइनेंशियल लॉस हुआ. व्हाई? बिकॉज अ लॉट ऑफ किड्स दे वेंट टू दिस पर्सन स्कूल. सो नाउ जीजीएस वेंट टू द कोर्ट सेइंग कि मेरा तो बहुत नुकसान हो रहा है बिकॉज दिस पर्सन हैज ओपनड अ स्कूल हियर. टू व्हिच द कोर्ट सेड दैट यस फाइनेंशियल लॉस है बट आपका कोई भी लीगल राइट वायलेट नहीं हो रहा है. ऐसा नहीं है कि a person does not have the right to open the school. He has the right. He's just using his right. हाँ, अगर आपके वहां पे they are going to open any court, okay, if there is going to be any if there is going to be any competitor, so of course there's going to be financial loss, but there is not necessarily any loss of, there is any legal injury that has happened. So damage हुआ है बट कोई भी लीगल इंजरी नहीं हुई है. लॉ ऑफ टॉर्ट सिर्फ एप्लीकेबल होगा उन सिचुएशंस में जहां पे लीगल इंजरी हुई हो. तो यहाँ पे कोई भी लीगल इंजरी नहीं हुई है, इसलिए कोई भी कोर्ट आपको इसमें कोई भी रिलीफ नहीं दिला सकता. ओके. सेकेंड इज इंजुरिया सिने डैमनो, इंजरी विदाउट डैमेज, ठीक है, कि इंजरी तो हुई है आपको, आपका लीगल राइट जो है वो लिया गया है, बट आपको कोई लॉस नहीं हुआ. जैसे कि द जजमेंट दैट वी अंडरस्टूड, द एशवी वर्सेस वाइट जजमेंट, व्हाट हैपेंड इन दैट जजमेंट? एशवी वर्सेस वाइट वाज वेरी सिंपल. एशवी हैड द राइट टू वोट, राइट, उसका राइट टू वोट इन्फ्रिंज हो गया. एशवी वांटेड टू कास्ट हिज वोट, ही कुडंट, राइट, एंड he was really upset about it. But in reality, exactly हुआ क्या था? Even when Ashby could not cast his vote, the candidate he really wanted to give vote to, he won the election anyway, right? तो ऐसा नहीं है कि Ashby के वोट ना डालने की वजह से कुछ नुकसान हो गया. जिस कैंडिडेट को उसने वोट डालना था वो तो भी जीत ही गया. तो अब इसमें वाइट ने कहा कि ठीक है, आई गेट इट दैट ही प्रोबेबली वाज स्टॉप्ड फ्रॉम कास्टिंग हिज वोट, बट देयर इज नो लीगल इंजरी दैट हैज हैपेंड. Damage has happened, legal injury has happened, but there is no damage that has happened. In which the court said that it doesn't matter. It doesn't matter if the damage has happened or not. We are more concerned about the legal injury. Legal injury has happened here. Okay. So, if in this case, White had to pay money to Ashby, had to pay compensation to him. So, what is important? What is the takeaway from this? That it is the legal injury that is important. अगर डैमेज हुआ है पर कोई भी लीगल इंजरी नहीं हुई है तो नो टॉर्ट्स एप्लीकेबल. लॉ ऑफ टॉर्ट्स कुछ नहीं कर सकता. इंजरी, लीगल इंजरी हुई है पर कोई डैमेज नहीं हुआ है, doesn't matter, law of torts will be applicable because we are more concerned about the legal rights and it's not the remedy that really it's not the damage that really matters to us. Okay, दो और मैक्सिम्स हैं. First is actio personalis moritur cum persona, which means that a personal action dies with the person. Okay, now let's say there are two people under law of torts, A versus B. ठीक है, इनका अभी डिस्प्यूट चल रहा है. लेट्स इनके डिस्प्यूट को चलते हुए 5 साल, 6 साल, 7 साल हो गए. इन दोनों में से कोई भी अगर कभी भी मर जाता है, if anybody of them dies, then the dispute will end automatically. It doesn't work in any other type of law. It only works under law of torts. Then the last is Q facit per alium facit per se, which says he who acts through another acts himself. Yani ki, if now let's say I am an employee and I am representing my organization here, and if I make any controversial statements, right, about anything, so when I am representing my when I'm representing an organization as an employer, as an employee, in that case, whatever I do, automatically it is going to be the responsibility or the accountability is going to be with the organization as well, right? So he who acts on the behalf of somebody else will also have the liability, right? So if I do something wrong with you or to you, the organization that I'm representing is also going to be responsible for the same. Okay. ओके, बहुत क्विकली करेंगे हम इसे, राइट, एंड वी जस्ट अंडरस्टैंड अ फ्यू डिफेंसेस अंडर लॉ ऑफ टॉर्ट्स. लॉ ऑफ टॉर्ट्स में कुछ बहुत अमेजिंग डिफेंसेस होते हैं हमारे पास, कि आपके पास अपनी सिविल लाइबिलिटी, अपनी टॉर्शियस लाइबिलिटी को एस्केप करने के लिए देयर कैन बी सम situations, right? Some defenses. First is voluntary non-fit injuria. Yani ki if you're consenting to the wrong. For example, you are sitting in a cricket stadium, right? You really like watching cricket matches and you want to watch the match live, and you are sitting there in the cricket stadium watching it live. Now, as a spectator, there is always a possibility that your favorite batter, he hits a six and the ball comes and hits your head, right? In that case, you get injured. So now you cannot go and say that, okay, this batter has hit me, I need compensation from him, I need money back from him, right? You cannot do that. Why? Because you were aware that if you're sitting in the stadium, it might happen to you. So in that case, you have consented to that situation and it is known as voluntary non-fit injuria. You cannot seek any legal benefit. Second is act of God. Act of God basically means anything which is done out of some supernatural forces. Usually हम इसमें natural disasters like floods and earthquakes and cyclones हम इसको consider करते हैं. तो कुछ भी ऐसा नुकसान जो कि any natural calamity या natural disaster की वजह से हो जाता है, उसमें law of torts applicable नहीं होता. You cannot go and say that, okay, maybe this earthquake has damaged this and I want compensation. No, the court says this is act of God. We do not have any legal remedy for the same. Okay. Next we have inevitable accident. Something which is, देखो inevitable का मतलब है that something which cannot be, could not be, something which we could not foresee, something which we could not predict, and something which we could not avoid. Okay. Now let's say you are driving on the road. Now, when once you started from your house, everything was absolutely fine. You were driving all good, the road was fine, everything was good, the car was also working really well. Now, suddenly, when you get into a crowded area, your car stops working, or maybe the brakes they go fail, right? The brakes fail, and you now there is no way you can protect anything. No way you can save anything. No way you can just get rid of that accident, right? It's inevitable. Brakes are not working. Or and when you started from your home back then, it was working really well, everything was fine. It was not that you were reckless. It was not that you were careless. It was just something which you could not predict, something which you could not foresee, something which is beyond your control. And if that accident now happens, it can be a valid defense that, sir, I was careful and I could not expect this to happen, but this is something which has happened. Okay. Inevitable accident. Next is necessity. Necessity is when you want to prevent a greater harm, you cause a smaller harm. Okay. Let's say you are driving on a road and it's a very क्या कहते हैं उसको? It's a very छोटा सड़क है, right? It's not very wide road, right? And while driving, what really happens that once you were driving, so another car comes, right? And you couldn't control your car. And to avoid an accident, right? You bump into a car, empty car right next to you. And you do so that you can avoid a head-on collision from the other car that is coming in front of you. So now just to prevent a greater harm, you have caused a smaller harm. That is the defense of necessity. Then another defense that we have is plaintiff as the wrongdoer. इसमें ये बोलते हैं देखो कि अगर the plaintiff himself, plaintiff is the person जिसके साथ गलत हुआ है, जिसने भी केस स्टार्ट किया ये बोल के कि मुझे compensation चाहिए, अगर उसकी खुद की कोई चीज में गलती है, then he cannot get justice in that case situation, right? Now um, let's say you are driving right on the road and there's another person who's driving. You are driving recklessly, but the other person is also driving recklessly. Okay? Both of you are driving recklessly and you bump into each other. There is a head-on collision. You take accountability of what all you have done wrong. He does not take his accountability and he says कि नहीं नहीं आपने मेरा नुकसान करा है, you have to pay compensation to me, and he goes to the court asking for compensation. And in that case, you can always say that the plaintiff was equally wrong. Plaintiff was also a wrongdoer, right? So in that case, when plaintiff himself is a wrongdoer, in that case the court says कि नहीं, फिर इसमें कोई भी remedy आपके पास available नहीं होगी, right? Yeah. And then finally statutory authority. अगर कोई भी चीज, ठीक है, कोई भी चीज by law authorized है for a person to do, right? In that case also there is no defense available. And last is any judicial act or judicial immunity which is available for the judges. So judges, while acting as a judge in the court of law, right? If they pronounce any judgment, if they do anything, it is protected under law of torts. आप ऐसा नहीं बोल सकते कि जज साहब ने मुझे इतना फाइन लगा दिया, जज साहब ने मुझे ये चीज बोल दी. That is not a defense that is applicable. Yeah. So that is not a defense that is applicable. So judicial acts and judicial immunity are also protected under law of torts, right? So yes, that was a very quick intro to law of torts. We are going to meet again very soon where we are going to continue the series of law of torts and I'll take you to some specific torts and tell you and explain you some specific torts that you definitely should prepare for your exam, right? So this was something I had to share with all of you today. We're going to meet very soon, probably next Monday now. And we'll continue the series and we are going to understand all of it in detail. All right. So, yes, that was my time with all of you today. Thank you so much, everyone, for joining. I'll meet you all very soon. Have a great week ahead. Thank you so much.